Hello friends, welcome to our informational series. Today we are going to talk about Information Technology Act, which is also known as IT Act or a cyber law. We'll cover what is cyber law, authorities under the cyber law, as well as civil and criminal remedies. So what is a cyber law? Simply put, cyber law is a law regarding information technology including computers and internet. Cyber law can also be considered as a legislation focused on acceptable behavioral use of digital technology, including computer hardware and software, the internet, and its networks. Indian cyber law broadly covers two aspects. It provides recognition and legal framework for electronic data exchange as well as mechanism to handle cyber wrongs and crimes. Some of the salient features of Indian law are: Act recognizes functional equivalence approach, which means that wherever law provides for information or any other matter to be in writing or typewritten or printed, then such requirement will be deemed to have been satisfied if it is in the electronic format. This includes recognition of the electronic signatures as well. However, some of the documents have specially been excluded from the ambit of electronic format. These are negotiable instruments, power of attorneys, trust deeds, wills, contract for sale of conveyance of immovable properties or any interest in such properties. Additionally, the Act recognizes certain wrongs or crimes if carried out over the electronic or internet medium. Some of the activities which have been made criminal under the Cyber Act are harassment using emails, cyber stalking, dissemination of obscene materials, cyber pornography, defamation, unauthorized control or access over computer system, email spoofing, computer vandalism, piracy, fraud or cheating using computers or internet, trafficking of drugs, humans using internet, and the cyber terrorism. In order to protect the government and citizens as well as their digital resources, the law establishes some bodies under the Information Technology Act. Certifying authority is responsible for issuing digital signatures to the users. It can be any company, LLP, firm, or person who has been granted license by the controller of certifying authorities. Controller of certifying authorities has been established to grant license and do supervision of activities of certifying authorities. It is responsible for resolving conflicts between the certifying authorities and subscribers should they arise. It has the power to investigate any contravention by certifying authorities. Adjudicating officers have been appointed under the Act to handle any contraventions of rules, regulations, or the Act itself. They can impose penalties or award compensation. They handle claims for injury or damage up to 5 crores. Any claim beyond 5 crores lies with the competent court. Cyber Appellate Tribunal is established by the central government to hear the appeals from both the controller of certifying authorities as well as those arising from the decisions of adjudicating officer. However, the orders with the consent of parties are not appealable. National Critical Information Infrastructure Protection Nodal Agency is responsible for taking all measures to protect critical information infrastructure in the country from unauthorized access, modifications, use, disclosures, disruptions, or incapacitations. It carries out research and development in the area of protecting critical information infrastructures and provides security awareness amongst the stakeholders. Indian Computer Emergency Response Team is a national nodal agency for critical information infrastructure protection in the country. It collects, analyzes, and disseminates information on cyber incidents and is responsible for developing emergency measures for handling cyber security incidents and coordinating emergency response activities. It publishes guidelines, white papers for information security practices and activities related to cybersecurity. Cyber Regulation Advisory Committee is constituted by the central government to advise central government in general. It provides inputs and directions regarding framing and modification of rules under the Act as well as guides the controller in framing the regulations under this Act. Let us see how civil remedies can be availed under the Act. Matters related to contravention of any provision, rule, regulation, or claims for damages up to 5 crores for cyber wrongs lie with the adjudicating officer of the state or union territory concerned. Both aggrieved person or any concerned authority can make application to the adjudicating officer. There is a ad valorem fees that needs to be paid by the applicant. The adjudicating officer will issue notice to the opposite party and fix a date for hearing. On conclusion of hearing, it will award compensation or impose penalties. In case of frivolous complaints, adjudicating officer can impose costs and fines up to 25,000. Application for compounding can be made to the adjudicating officer anytime, even before complaint has been filed or reported. The adjudicating officers can also get the matters investigated further by officers of controllers or CERT or concerned deputy superintendent of police. In case the adjudicating officer is convinced that the scope extends to any offence under the Act, then instead it can transfer the case to the concerned magistrate. All certifying authorities need to register with the controller on payment of fees and submission of performance bond. The registration is for the fixed term of 5 years and has to be regularly renewed. In case of contravention of any of the terms by the certifying authority, the controller can hold inquiry and after giving opportunity of hearing, suspend or cancel the license. Suspension or termination can result in imposition of penalties. Any conflict or issue between the subscriber and certifying authority is also handled by the controller. Now let us see the criminal remedies available under the Act. The Act declares certain activities in the digital world as cyber crimes. The aggrieved is at the liberty to report the same to the police like any other crime. Most of the crimes under the Act have been made cognizable, implying that the police can take FIR and initiate investigation. However, as such crimes require special investigation skills, there are special cyber cells in most of the states to handle such investigations. While investigating cybercrimes, the police have all such powers as they have in case of any other cognizable offense. They can search, take statements and even arrest. However, as many of the offenses under the Act are bailable, one can get bail at the police station itself at the time of arrest. In case the offense involved is more serious in nature, then the police after arresting will produce the accused before the concerned magistrate and try to take his police custody and then subsequently ask for his judicial custody also. Bail in such cases will have to be applied before the magistrate. Once the investigation is over, police submits charge sheet, after which the magistrate may take cognizance and admit the case in lines with CRPC based on the severity of the offense committed. So this is pretty much the wrap up of concepts of cyber law or Informational Technology Act in India. Hope we have been able to clarify your doubts. Thanks for watching. Stay tuned.